Our next witness is the Honorable Todd Portune, who's a commissioner for Hamilton County, Ohio.
Good morning, Chairman Graves and Representative Esty and members of the subcommittee. It's an honor to be here today to testify before this subcommittee. My name is Todd Portune, and I serve as president of the Hamilton County Board of County Commissioners in Ohio. Today, I am representing the National Association of Counties. Hamilton County, Ohio is considered primarily urban, with a population of almost 808,000 residents located in southwest Ohio. The county seat is in Cincinnati, which is the third largest city in Ohio. The topic of this hearing is of great importance to counties across the United States that are dealing with increased responsibilities and unfunded mandates under the Clean Water Act as co-regulators and as regulated entities. This includes the rising expenses associated with Clean Water Act, wastewater-related wet weather consent decrees with tighter stormwater requirements, and the limited capability of our counties and residents to absorb the cost of these additional outlays. Today, as you continue to assess how integrated planning can be used to achieve federal water quality goals, I'd like to share with the committee 3 key points for consideration. First, integrated planning can help counties address the growing list of Clean Water Act needs. Over the years, the number of federal regulations and requirements facing counties have increased dramatically. This growing number of regulations comes at a time when counties, regardless of their size, are experiencing significant fiscal constraints, and our capacity to fund compliance activities is often limited. In fact, over 40 states put significant restrictions on counties' ability to generate revenue or to collect taxes. Additionally, the federal government has increasingly been using litigation-driven consent decrees to drive tighter requirements for combined sewer overflows and sanitary sewer overflows at wastewater treatment plants. In some cases, the cost of these consent decrees have ranged from hundreds of millions to billions of dollars per county. In my county, we oversee the Metropolitan Sewer District of Greater Cincinnati, serves almost 300,000 households. But since 2006, Hamilton County and the Sewer District has been required to comply with a consent decree for a federal water quality noncompliance issue on our wastewater sewage system. As a result, the county and our taxpayers are required to invest over $3 billion at 2006 rates in additional projects and infrastructure upgrades. In the past 10 years alone, Hamilton County has spent over $1 billion, with over $2 billion still to go under our decree. Close to 1/3 of Hamilton County lives below the federal poverty level. They're the ones most hard hit by these new requirements and under the consent decree and other associated costs. Since we began, our sewer rates have increased approximately 350%, and over the next 20 years, annual sewer rates will rise from $844 a year to $2,748 a year when we finally meet the terms of the consent decree. Unfortunately, my county is not an isolated case, and stories like this are being retold across the United States. Second, integrated planning offers a path for counties to meet the growing universe of Clean Water Act regulations in an environmentally sensitive, streamlined, and cost-effective manner. That's why EPA's integrated planning framework is so attractive to counties. Recognizing that water affordability is a huge problem, EPA set in place a framework to allow EPA regions to work collaboratively with states and impacted local governments across the universe of water mandates. Under the plan, counties can prioritize their local water quality and infrastructure goals across all Clean Water Act programs based on the most pressing issues within their community. Had this been available to us at the very beginning in lieu of a consent decree, Hamilton County could have saved county residents a lot of money. Unfortunately, to date, the EPA regional offices have not used integrated planning to the extent that they could. Which brings me to the final point. Congress and the administration have a perfect opportunity today to protect water quality in ways that are affordable to counties and their residents. This opportunity has been created by a number of bills that have already been introduced, including those that have moved through committee in the Senate. We thank the sponsors of those bills for their work toward passing legislation to codify EPA's integrated planning framework. In conclusion, and on behalf of America's 3,069 counties, we thank you, the subcommittee, the opportunity to testify today about providing us, America's counties, with the flexibility to work with the EPA as a true partner, saving county ratepayers nationally close to hundreds of billions of dollars in the process, while meeting Clean Water Act requirements. I'll be happy to answer any questions that the subcommittee may have, and I refer to the written testimony as well that we have submitted on behalf of NACo.